Hello everyone, welcome to EduTap. I am Arshdeep Kaur and I am here with another video on the Contract Act. We have done one video on the Contract Act and we have covered important provisions there as well. And now we will be doing some more questions on the Contract Act, right? So let's begin. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. They are going to be very important for your revision. And what you get in this, you get chapter-wise tests, sectional tests and full-length tests, right? Also, we have come up with a live crash course. It is also for both the phases, phase 1 and phase 2. It includes the test series I've just mentioned, and also you get live classes on all the subjects, and you get 60 plus live classes, 2 hours each. You also get one-on-one mentor support. So if any one of you have not enrolled yet, we are running a limited time offer. So if anyone wants to avail it, can refer to the link in the description below. Let's begin part 2, question number 1. As a general principle of law of contract, which of the following is not an essential for a valid contract? So yesterday we did that who is competent to contract. Now the question is that what is an essential? What is not an essential of a valid contract? So now we are going to discuss what are the valid essentials of a valid contract. What are the essentials for a valid contract? Writing, competency to contract, lawful consideration and lawful object, free consent. The answer is option A. It is nowhere mentioned that a contract has only been in writing. So writing is not essential for a valid contract, right? Question number 10, section number 10, what agreements are contracts, right? So what agreements that have been made, which of these agreements they are contract? All agreements are contract if they are made by the free consent of the parties. If they are made by the free consent of the parties, there is no misrepresentation, there is no undue influence, there is no fraud, right? So if it is made by the parties with free consent, for a lawful consideration and with lawful object. The consideration is also lawful and the object is lawful. And the object is also lawful. The object cannot be drugs, it cannot be gambling, right? So both the consideration and the object, it has to be lawful and are not hereby expressly declared to be void. And if they are not declared to be void in this act, then it is a valid contract, right? So the term writing has not been mentioned. That means writing is not an essential element to form a contract, right? It can be an oral contract also. Question number 2, the age of majority for the purpose of contract is 18, 21, 16, 18 years for girls and 21 years for boys, 15 years for boys and girls both. So this also we have done yesterday. It is 18 years as per the Indian Majority Act, right? Let's read it first. According to the Indian Majority Act 1875, the age of majority in India is defined as 18 years. So it is defined as 18 years. For the purpose of entering into a contract, even a day less than this age disqualifies the person from being a party to the contract. And if you are of 17 years of age, if you are one day less than 18 years, then also you are not competent to contract, right? Any person domiciled in India who has not attained the age of 18 years is termed as minor. So we are not concerned with minors here. A major person only is competent to contract, right? Question number 3. A contract dependent on the happening or non-happening of a future uncertain event is. It is a contingent contract. If we see section 31 defines contingent contract. So if a contract is based on a happening or a non-happening of a thing, right, then it is called a contingent contract. So the happening or a non-happening thing, that is collateral to the contract, right? It is not the sole determining factor to the contract. Let's read it. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen, right? So a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Let's take examples first. A contracts to pay B rupees 10,000 if B's house is burnt. So he will only pay B this amount if B's house is burnt. This is a contingent contract. right? So this is a contingent contract because it is based on the happening or the non-happening of the event. If the house is never burnt, he is never going to pay. So it is dependent on that uncertain future event. That is why it is known as that is why it is known as a contingent contract, right? Question number 4. A agrees to pay rupees 10,000 to B if a certain ship does not return. If the ship returns, then the contract becomes. The answer is option A, then it becomes void. Or if a contingent contract, if a thing was to happen and it does not happen, it becomes void. And if it was to happen and it does happen, and if it was not to happen and it does happen, then also it becomes void, right? Let's read it, then it will be more clear to you. Enforcement of contracts contingent on an event happening. First of all, if the condition said that an event happening, it was a positive condition, right? Contingent contract to do or not to do anything if an uncertain future event happens cannot be enforceable by law unless and until that event happens. So if A says that I will pay you this much amount if your house is burnt, if his house is burnt, then only it is a valid contract. If it is not burnt, then it is not going to be a valid contract, right? So it will only and only come in force. It will only be enforceable when that thing, then the burning of the house, when that happens, right? If the event becomes impossible, such contract becomes void. And if that event, that happening of the event, that becomes impossible, then such contract becomes void. Second is, A contracts to pay B a sum of money when B marries C, right? So A, he contracts with B that I will pay you this amount when you marry C. But here C dies without marrying B. So here it becomes impossible and this contract is void. Enforcement of contracts contingent on an event not happening. So now this is talking about an event not happening, right? It is a negative condition. So contingent contract to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not before. If it becomes not happening of that event becomes impossible, then it is void contract. Let's read it. A agrees to pay B a sum of money if certain ship does not return, right? If it does not return, the ship is sunk. Now this is going to be enforceable by law. So the contract can be enforced when the ship is sunk. On the other hand, if in this situation the ship returns, then it is going to be it is going to be void, right? It is going to be turned into a void contract. Question number 5. Reasonable time for the performance of contract is a question of fact, law, mixed question of fact and law, of prudence, none of the above. The answer is option A, that is of fact, right? So if we read section 46, whereby the contract a promisor is to promise his promisee without application by the promisee. This is important. Without application by the promisee, and no time for the performance is specified, the engagement must be performed within a reasonable time. So where no time is mentioned, there it will be the reasonable time, right? So where no time is mentioned, it is going to be a reasonable time. And without application of the promisee means that the promisee does not have to ask for it. He does not have to request for it, right? So if he does not have to request for it and time is specified, then in that case the time will be the reasonable times, right? It will be within a reasonable time. And to question whether it is and the question what is reasonable time is in each particular case a question of fact. It is a question of fact, right? It has to be taken out from the circumstances of the case. Next question. Claim of necessities supplied to a person incapable of contracting or on his account is provided in. It is section 68. Let's read the section. If a person incapable of entering into a contract, who are incapable to entering into a contract if he is not major and he is of unsound mind, right? So if a minor or a person of a unsound mind or any other whom he is legally bound to support, who is legally bound to support, that person who is incapable of contracting, right, is supplied by another person. Now a third person is coming into picture. He is supplying to such persons with necessities suited to his condition in life. So he is providing with necessities suited to them in that condition. They should be suited, they cannot be luxurious items, right? So with necessities suited to him conditions in his life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So he will be reimbursed from the property of such person. So what is this section basically saying? For example, A is of unsound mind, right? And B, what B does is B provides some kind of financial support to who? To A and to his wife as well. In this case now B is entitled to be reimbursed from the A's property, right? So this is what this section is. If a person incapable of entering into a contract on any other or anyone whom he is legally bound to support, because he is legally bound to support his wife, right, is supplied by another person with necessities suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Let's read some illustrations. A supplies B a lunatic with necessities suitable to his condition in life. A is entitled to reimburse from B's property. A supplies the wife and children of B a lunatic with necessities suitable to their condition. With the necessities suitable to their condition, right? A is entitled to be reimbursed from B's property. Next question, question number 8. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as, so he is subject to the same responsibility as a bailee. In that case, he will be deemed to be a bailee. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee. Question number 9. Which of the following provisions of Indian Contract Act deals with the liability of a person to whom money is paid or thing delivered by mistake or under coercion? So which section is it? It is section number 72, right? So liability of a person to whom money is paid. A person to whom money has been paid or anything delivered by mistake or under coercion. It is either by mistake or under coercion. He has to repay or return it. He has to repay it. Either he has to repay it or he has to return it. This has been given in section 72 of the Indian Contract Act 1872. Right? Let's read the illustration as well. A and B jointly owes 100 rupees to C. A alone pays the amount to C and B, without knowing that A has paid, he also pays 100 rupees to C. Now here C is bound to pay 100 rupees back. Here C is bound to repay B because he has already received what he was liable for. So that is why he has to now repay B, right? This was the illustration. This is very easy. Question number 10. Section 75 of the Indian Contract Act provides for, the answer is option A, party rightfully rescinding contract entitled to compensation. Let's read the section. A person who rightfully rescinds a contract is entitled to compensate. So a person who rightfully rescinds matlab it is not his fault that he is cancelling this contract. It was the other party's fault, right? So a person who rightfully rescinds a contract is entitled to compensate for any damage which he has sustained there through the fulfillment of the contract. So, right, in that case, he is entitled to get compensation. Question number 11. Which section of the Contract Act defines proposal? Yesterday, we have done the definition of proposal. So, which section was it? It is section 2A, right? When one person signifies to another his willingness to do or not, or to abstain from doing anything with a view to obtain his assent. The intention is to obtain the assent of that other to such act or abstinence, he is said to make a proposal, right? Question number 11. Question number 12. Substitution of an old contract with the new one is, it is called novation of the contract, right? Let's read it. Novation of the contract, and what is the effect of this novation? This is given in section 62. If the parties to the contract agree to substitute a new contract for it or to rescind or alter it, the original contracts need not to be performed. If both the parties are agreeing, then the old contract, it needs not to be performed, right? Let's read it. A owes money to B under a contract. It is agreed between A, B and C that B shall thereupon accept C as his debtor. instead of A. The old debt of A to B is at the end, and a new debt from C to B has been contracted. For example, A has to pay B 10,000 rupees, right? So what A does is, A says to B that I have to take 1,000 rupees from C. So what you do, you take directly from C. You take that 1,000 rupees directly from C, and all of these parties, A, B, C, all of them, they agree. C agrees that okay, I have to pay A, so directly what I'm going to do is I'm going to pay B instead of paying A instead of paying A. Right? So this is valid. This is known as novation, because they have altered the terms of the contract. They have agreed upon it. So this is valid, and this is known as what? This is known as novation. Question 13. What is a contract as per Indian Contract Act 1872? The answer is option B, agreement enforceable by law. So if we read section 2H, the definition says an agreement enforceable by law is a contract, right? So an agreement which is enforceable by law, it is termed as a contract. Question number 14. The right concerning a contract are decided by. So who decides the terms of the contract? Is it the parties? Is it the Indian Contract Act, the law of equity, all of the above, or none of the above? The answer is parties to the contract. The terms concerning the rights. So the terms and the rights concerning a contract, they are decided by the parties to the contract. Rights concerning a contract are decided by the parties to the contract. Question 15. Where persons reciprocal promises firstly to do certain things which are legal, and secondly under specified circumstances to do certain other things which are illegal. The first set of promise is dash and the second set of promise is dash. So the answer is option C. The first is contract and the second is void. If we read section 57, when person reciprocally promises firstly to do certain things which are legal. So firstly he promises to do something which is legal, and secondly to do something which is illegal, under circumstances to do certain other things which are illegal. The first set of promise in a contract, the first set of promise is a contract. First is going to be a valid contract, but the illegal part, it is going to be a void agreement, right? It is not going to be enforceable by law. Now question for achievers. A tender in a newspaper. A tender in newspaper is it invitation to offer? Is it a promise? Is it an offer, invitation to acceptance, or a contract? So you have to comment the right answer below. So that's all for today. I hope this was a helpful session for you. This was our second lecture on the Contract Act, and there is going to be one more video on contract law, right? So I hope this was helpful for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.